The Salem Witch Trials. When fear became evidence in 1692, a colonial court sent 19 people to the gallows for attacks no one could see, test, or disprove. There were warrants, there were depositions, there were confessions. On paper, there was a legal process. But here was the paradox. In Salem, confession could keep you alive, while denial could move you closer to death. So how does the justice system reach that point? How does fear become evidence? And how does invisible harm become a sentence of execution? That is the real question of Salem. Not whether witches were real. The historical record gives us no reliable evidence that the accused had supernatural power. The harder question is how a community, a church, and a court convinced themselves that invisible attacks could become proof. This is the story of the Salem Witch Trials. Not as a ghost story and not as a seasonal myth, but as a legal disaster. A case study in what happens when panic is organized, when accusation becomes momentum, and when a justice system stops asking whether its evidence can survive doubt. The setting was Salem Village in the Massachusetts Bay Colony, not the Salem of souvenir shops and modern museums, but a tense Puritan settlement in a fragile political world. The colony had recently lived through the loss of its old charter. A new royal charter arrived in 1691. The region was touched by war, displacement, frontier violence, religious conflict, and local rivalry. Families argued over land, church leadership, taxes, and power. People believed deeply in God, the devil, and the spiritual dangers surrounding them. In that world, misfortune did not always look random. A sick child, a dead animal, a failed crop, or a bitter argument could feel like evidence of hidden evil. In January 1692, Reverend Samuel Parris's 9-year-old daughter, Betty Parris, became ill. Soon his 11-year-old niece, Abigail Williams, showed similar alarming behavior. The girls reportedly suffered fits, strange movements, and intense distress. After prayer, fasting, and home remedies failed, a local doctor was said to have described the problem as bewitchment. That word changed everything. By late February, the girls had named 3 women as the source of their invisible torment: Sarah Good, Sarah Osborne, and Tituba. The choices were not random. Sarah Good was poor and socially vulnerable. Sarah Osborne had legal and church conflicts. Tituba was an enslaved woman in the Parris household, already positioned at the edge of power and protection. On March 1, 1692, the 3 women were examined in the Salem Village meeting house. Sarah Good and Sarah Osborne denied the accusations. Tituba, under pressure, confessed. She described a wider, invisible conspiracy and suggested there were more witches still hidden in the community. For frightened people, that confession did not close the case. It opened the door. If there were more witches, anyone could be next. If invisible forces were moving through the village, normal rules of proof seemed too slow. The accusation spread. More girls and women reported torment. More names were spoken. Martha Corey, Rebecca Nurse, Elizabeth Proctor, John Proctor, George Burroughs, Giles Corey. Sarah Good's young daughter Dorothy was also pulled into the machinery of suspicion. The case was no longer about 3 women. It was becoming a public system. To understand Salem, we have to understand the evidence that made the trials infamous: spectral evidence. Spectral evidence was testimony that the accused person's specter, or invisible likeness, had appeared to an accuser in a dream or vision and caused harm. A witness might say that a specter pinched them, choked them, tempted them, or commanded them to sign the devil's book. The accused person could be standing across the room, but the claim was that their invisible image had attacked. To a modern court, that kind of claim cannot be cross-examined in any meaningful way. There is no physical trace. No independent witness can reliably see the same apparition. The accused cannot prove where their specter was not. But in Salem, the court of Oyer and Terminer accepted this kind of evidence. Governor William Phips created that special court in May 1692 to hear the growing witchcraft cases. William Stoughton, the lieutenant governor, became its chief justice. The court was supposed to restore order. Instead, it gave panic a formal structure. Bridget Bishop became the first person tried and condemned by the court. During her examination, witnesses claimed they were afflicted by her presence or by her likeness. Bishop denied the charges again and again. She said she was innocent. She said she knew nothing of witchcraft. but in a courtroom built around invisible injury, denial could sound like defiance. Ordinary movements could be treated as signs. Old rumors could return as evidence. A strange piece of clothing, a neighborhood grudge, a past conflict, or a reputation for not fitting in could be pulled into the same story. Bridget Bishop was executed on June 10, 1692. After that, the machinery moved faster. On July 19, Rebecca Nurse, Susanna Martin, Elizabeth Howe, Sarah Good, and Sarah Wilds were hanged. On August 19, George Jacobs, Martha Carrier, George Burroughs, John Proctor, and John Willard were hanged. On September 23, Martha Corey, Margaret Scott, Mary Eastie, Alice Parker, Ann Pudeeter, Wilma Red, Samuel Wardwell, and Mary Parker were hanged. 19 people were hanged in all. Giles Corey suffered a different fate. He refused to enter a plea which blocked the court from trying him in the ordinary way. In September 1692, he was pressed under heavy stones and died. The method was brutal, but the principle behind it was also revealing. Salem was not only afraid of witches, it was afraid of resistance to the court itself. At least 5 more people died in jail. The jails were not waiting rooms for justice. They were cold, expensive, dangerous places. Families could be charged fees. Property could be lost. Reputation could be destroyed even before any final judgment. And this is where Salem's paradox becomes impossible to ignore. If you confessed, you could become a witness. You could name others. You could be folded into the prosecution's story as someone who had been captured by evil but might still be useful. If you denied the charge, you became a problem for that story. Your refusal could be read as stubbornness. Your fear could be read as guilt. Your ordinary body, your glance, your silence, even your clothing could be interpreted through a theory you had no way to disprove. Nearly 50 people confessed to witchcraft. That number should not be read as proof of guilt. It should be read as proof of pressure. In a system where confession made you useful to the prosecution and denial made you dangerous, survival itself could bend testimony. The court did not act alone. Ministers, magistrates, neighbors, accusers, jurors, and families all became part of the process. Some urged caution. Some believed the danger was real. Some had doubts but moved with the crowd. Some saw enemies named and old conflicts transformed into moral certainty. That is one reason Salem still matters. The trials were not simply a story of irrational villagers. They were a story of institutions. The meeting house, the jail, the magistrate's table, the special court, the written warrant, the sworn deposition, and the death sentence all gave fear the appearance of order. By October 1692, that order began to crack. Public confidence was turning. Accusations had reached people whose status made the crisis harder to ignore. Ministers warned against reliance on spectral evidence. Governor Phips intervened. He ordered that spectral evidence no longer be used in the same way, and he dissolved the court of Oyer and Terminer. The next court, the Superior Court of Judicature, handled the remaining cases in 1693. Without the same dependence on spectral evidence, the prosecutions collapsed. Many people were acquitted. Others were reprieved. The executions stopped. But stopping the trials did not repair the damage. Families had lost mothers, fathers, husbands, wives, neighbors, land, money, and names. Children had watched adults turn terror into procedure. Communities had to keep living with each other after the accusations ended. The reckoning came slowly. In 1697, Massachusetts called for a day of fasting and prayer. Judge Samuel Sewall publicly acknowledged his guilt for his role in the trials. In 1702, the Massachusetts General Court declared the trials unlawful. In 1711, the colony reversed the attainder for a group of named victims, restoring civil rights in law, though not restoring lives. The process remained incomplete for centuries. More names were cleared in 1957 and 2001. In 2022, Elizabeth Johnson Jr., convicted in 1693, was finally exonerated after students and advocates pushed Massachusetts to correct the record. That late exoneration matters because it reminds us that injustice can outlive the courtroom. A legal error can become an archive label, then a family memory, then a cultural symbol, unless someone returns to the record and asks what the state still owes the dead. So what was Salem really about? It was about fear, but not fear alone. It was about evidence. It was about who gets believed. It was about what happens when social suspicion is translated into legal fact. It was about a court that accepted claims the accused could never disprove. It was about a community that mistook intensity for truth. There is a reason the phrase witch hunt still survives in political language, even though it is often misused. Salem is remembered because it shows how accusation can become contagious. But the deeper warning is more precise than that. A justice system does not fail only when it is chaotic. Sometimes it fails while taking notes. Sometimes it fails with warrants, signatures, hearings, and formal language. Sometimes it fails because the people inside it believe certainty is the same thing as proof. The Salem Witch Trials ended. The people executed in Salem did not return. The people who died in jail did not receive the future apologies written in their names. The records remain: examinations, warrants, depositions, confessions, denials, reversals, and exonerations. And inside those records is a warning that still feels current. When fear becomes evidence, innocence has almost no defense. When a court accepts what cannot be tested, denial becomes useless. And when a community decides that invisible danger is everywhere, the next name spoken may be enough to destroy a life. Salem was not only a tragedy of the past, it was a test that law failed under pressure. The question it leaves behind is simple and uncomfortable. If the people of Salem could build a courtroom around fear, what protects any society from doing the same thing again?